Last year, wage and hour was a big area. This year, there were a number of things that were passed, but a lot of them are just tweaks to things that existed before. So I'm going to run through those really quickly because there's some other more significant things that are going on than just the wage and hour issues. AB 2103, non-exempt employee salaries. Everyone knows if you have a non-exempt employee that you have to pay them straight time and you have to pay them overtime if they work overtime. It is permissible in California to pay an employee a set, quote, salary for a certain number of hours to be worked. There was a California case a couple of years ago that said that those hours could include overtime hours as long as you paid the employee minimum wage, as long as they kept track of their hours, and as long as you had a written agreement. So, for example, you could agree to pay an employee $1,000 a month or $1,000 a week for 50 hours of work, which would include straight time and overtime. The legislature, in their wisdom, said, "No, we don't like that." So now, if you have one of those written agreements, you can only cover straight time. So essentially, if you have an agreement to pay an employee a flat amount, it will only cover 40 hours a week. And so really the point is, why even have an agreement? You might as well just take the amount you're going to pay them, divide by 40, pay them hourly, pay them overtime, and avoid any confusion. SB 1255, itemized wage statements. This is a huge, huge area for litigation. Plaintiffs' lawyers love this because, as everybody knows, you have to give your employees, when you pay them, you have to have a pay stub that lists certain required things, the hours that they work, the rate of pay, the total pay, all those types of things. If those wage statements do not include all of the required elements, then that creates a cause of action. There was a California case that said, if you violate the wage statement rules by just not having certain information on there, that unless the employee could show actual injury, they could not recover under the statute. The legislature didn't like that. So now injury is defined to include any inaccurate or incomplete wage statement. By law, creates injury to the employee. So therefore, if you have a violation of the itemized wage statement law, the employees will be able to sue you, so make darn sure that your wage statements are accurate and complete and comply with the law. Wage Theft Prevention Act. This is the law that requires at the time of hiring or in a change of information changes, you need to give the employee a notice that was specified by the DLSE concerning certain information, who they're working for, what their rate of pay is, those types of things. This statute has been amended to now include temporary services employees, those who, in other words, are hired by contracting companies and go to work for other companies. The information statements now need to include the name of the employer where they're actually going to be working, information about that employer, the address and the phone number, and also the rate of pay and hours for each assignment. So anytime one of those temporary services employees changes assignments, they need to get a new statement. AB 2675, written commission agreements. I think everybody, if you came last year, we talked about this. This law was actually passed last year, but it didn't go into effect until January 1st of this year, which anybody who has commission employees needs to have a written agreement concerning those commissions. They did, in their infinite wisdom, did tweak the statute a little bit to say that if you're giving an employee a short-term bonus or a temporary sales incentive, that's not a commission agreement. In other words, if you're paying the employee more money, they don't care if you have the written agreement. But if you have commissioned employees, you need to have a written agreement. AB 1855, labor and services contracts. If you hire someone in certain sectors, and they're listed farm labor, garment, janitorial, security guards, and now it includes warehouse workers. If you hire contract employees to work, a contractor who's going to provide you employees to work in one of those fields, your contract with the contractor needs to include certain language about enough money being in the contract to pay those employees their wages, or you as the hiring party will get into trouble. So you need to make sure if you have subcontractors who do that kind of work for you, that you comply with those requirements. And finally, SB 1144, wage judgments. This increases the fine and creates criminal liability, a misdemeanor, for any employer who does not pay and has the ability to pay either a Department of Labor Standards Enforcement wage judgment or a court judgment regarding wages of a departed employee. So, I mean, it's kind of good, kind of logical and good sense that if you go to the DLSE and they tell you owe the employee some money that you should pay them. But if you don't, you now have increased penalties and you also have the possibility of criminal violation.